Divorce and the family. An annulment is a court order to set aside a marriage by arguing that the marriage was not legal in the first place. The grounds for an annulment are very specific and may involve the following: a missing requirement of marriage, such as genuine consent or mental capacity; a legal defect in the ceremony; non-consummation of the marriage, that is, no sex; marriages of convenience, such as marrying someone for immigration purposes, may be allowed to stand even if there is no consummation. A separation occurs when a married couple decides not to live together anymore with the intention of formally ending the marriage. Some couples never divorce for religious or other personal reasons. Separation itself does not end a marriage, only divorce does. A couple can reconcile, that is, get back together, if they can live together again for up to 90 days. A divorce is the process that legally ends a marriage. The applicant is the spouse that initiates the divorce action in court. The respondent is the spouse being sued for divorce. The application has to contain the grounds for the divorce. A valid ground for divorce is adultery, voluntary sexual intercourse with someone other than a spouse. A co-respondent is the third party that participated in the adultery. A divorce application contains the following information: where and when the marriage occurred, the grounds for divorce, if there are any children, their names and ages, custody of and access to any children, financial support for the children, financial support for the applicant if necessary, and a division of property and assets. A sensitive aspect of parents seeking a divorce is the effect that terminating their marriage will have on their children. The following things must be determined: custody, the care and control of the child or children awarded to one or both parents; access, how much visitation the non-custodial parent is entitled to and how much financial support he or she must provide; best interests of the child. This is the guiding principle that a judge uses to make decisions regarding the child custody and access. When determining custody and access, a judge considers the following factors in determining the best interests of the child: the child's needs, the stability of the home environment, keeping siblings together, parent-child relationships, the child's culture and religion, the abilities and conduct of each parent, support available from relatives and friends, and the child's own wishes, depending on the age and maturity of the child. Shared parenting, also known as joint custody, is an arrangement between divorcing parents to have equal or similar rights in their child's care and custody. A positive aspect of shared parenting is that the relationship between the parents is often less bitter and it focuses on the children. In recent years, Canadian courts have moved in a new direction. If parents involved in a bitter divorce cannot compromise or resolve their differences, neither may receive custody of their children. When one parent is granted sole custody of a child, the non-custodial parent is usually granted a degree of access or visitation to the child. Access includes spending time with the child and receiving information about them, such as their progress in school and advance notice if the custodial parent needs to move. Reasonable access entitles a non-custodial parent to regular visits with his or her children. Defined access entitles a non-custodial parent to a series of scheduled visits. Supervised access is the most strict type. Visitation by the non-custodial parent must be supervised by a third party. A custodial parent may be allowed to move over the objections of the non-custodial parent if the move is thought to be good for the children. Custodial parents may wish to move if they plan to marry someone else who lives elsewhere, or they want to be closer to family and friends. Their job is relocated, or they get a new job. they experience serious problems with a non-custodial parent and wish to move further away. Mediators are used frequently when a marriage breaks down. Family mediation attempts to resolve family disputes, such as custody or division of assets, while avoiding a court battle. Mediators in family law are usually social workers, psychologists, or lawyers. The main point of family mediation is to provide a safe and supportive setting for the spouses to resolve their issues, especially regarding any children they may have. It encourages cooperation and compromise. All parents have the right to raise their children according to their own beliefs and values without government involvement. However, in recent years, Canadian courts and other public officials have increasingly intervened in cases that they believe involves child abuse. Child abuse is behavior that endangers a child's physical or emotional well-being. None of the various types of child abuse are acceptable in Canada. Parents may lose custody of their children if they are found to be abusive to them. There are many types of child abuse. Physical child abuse, including deliberate force against a child, including hitting, biting, choking, shaking, poisoning, or burning a child. Sexual abuse, sexual activity with the child, incest, or any type of sexual exploitation of the child. Emotional abuse, attacking a child's self-esteem, including terrorizing or humiliating a child. Neglect, that is, failing to look after a child's basic needs. If a child is being abused by his or her parents, authorities may remove the child from the parent's custody, and the court can issue a temporary or permanent wardship order. A temporary wardship, also known as a society wardship, provides legal custody of the child to a child protection agency until it is deemed that the parents are fit to resume their responsibility. A permanent wardship, also known as Crown wardship, provides permanent legal custody of a child to the Crown, who is represented by a child protection agency.